a little bit more about discrimination in the workplace. My name is Monique Gonzalez, as Vicki mentioned. A little about me, I joined the university in 2017 as a supervisor in the dining department. And I've spent the last 2 years working under Stacey in the Human Resources Department. And I'm very happy to be here today to present for you guys. And Stacey, would you like to introduce yourself?
Well, I won't tell you what year I came to the university, but I've been here a very long time, and I'm really committed to the university. I've loved my career here, and I've worked in equal opportunity for a lot of many years. And I asked Monique to do this presentation, so I told her I'd do it with her. So, so between the two of us, we're gonna, show you what we consider to be the guiding principles kind of discrimination in the workplace. And we'd sure love it if we could see you, and we'd really like it too if you, if you have questions at anywhere along the way, that you just pipe up and ask away. There aren't that many of us here, so we'd love to have this be a little more interactive and answer your questions as we go along.
Perfect. All right. So as Stacey mentioned, feel free to use the chat option or unmute yourself, and if you have questions along the way, but we'll go ahead and get started. So as you navigate your professional career, you may encounter situations that fall under one of the following types of damaging behaviors. This could be unprofessional behavior, which is just flat out bad behavior. This could be things like being unkind or being rude. Then it moves into prohibited behavior. So those are things like threats, being aggressive, intimidating others, hostile or violent behaviors, attempts to instill fear in others or subjecting them to emotional distress. And then, of course, there's illegal behavior, which is harassing another person based on a protected class. So some suggestions are, if you're in the work area, what are the values of your organization? Learn about the rules and expectations of your employer. Doing your homework and just finding out what's expected of you as an employee.
Well, and I think, Monique, the idea of prohibited behavior, I think that's really about the organization that you work for or the organization that you're part of. And those prohibited behaviors can be a lot of different things. And so I think finding an organization that you work for or associated with that represents your values is really important. And I think all of that information should be out there, right? And available to you if you just look for it.
Absolutely. So what exactly is discrimination? Discrimination is illegal or unjust discrimination is the treatment of different categories of people, especially on the basis of race, ethnicity, national origin, skin color, sex, gender, or sexual orientation, religion, age, pregnancy, mental or physical disability, genetic information, marriage to or association with another person because of the because of the above categories. All right, so jumping into race discrimination, it is illegal to treat applicants or employees unfavorably because they are of a certain race or because of personal characteristics associated with race. Treating someone unfavorably because of skin color or complexion is also illegal. National origin discrimination involves treating applicants or employees unfavorably because they are from a particular part of the country or the world. And then sex, gender, and sexual orientation. So the Equal Pay Act of 1963 states that employers must give all employees equal pay for equal work. Further, the Act specifies that job content, not the title, determines whether jobs are substantially equal. Title VII of the Civil Rights Act also prohibits discrimination based on sex. It is illegal for employers to pay people different salaries based on their sex or gender. Also in June 2020, the US Supreme Court held that an employer who fires an individual merely for being gay or transgender violates Title VII of the Civil Rights Act. Prior to this decision, the LGBTQIA+ candidates were protected from employment discrimination in fewer than half of the US states. Religious discrimination. So it is illegal for employers to discriminate based on an individual's religious customs. And businesses are required to make reasonable accommodation of an employee's religious belief if doing so does not have excessive negative consequences for the employer. And then age discrimination. So age discrimination is a practice specifically prohibited by law. With a few rare exceptions, companies are forbidden from specifying an age preference in job advertisements. Employees must receive the same benefits regardless of age. The only exception being that when the cost of providing supplemental benefits to young workers is the same as providing reduced benefits to older workers. And also age discrimination in apprenticeship programs or internship opportunities is also illegal. And then moving on to pregnancy discrimination. So pregnancy-based discrimination, of course, is illegal. Employers are required to respond to pregnancy in the same way that they would manage a temporary illness or other non-permanent condition that would necessitate special consideration. So job seekers have the same rights as employees, and both are protected by the Pregnancy Discrimination Act passed in 1978. Disability. So the Americans with Disabilities Act, or the ADA of 1990, made it illegal to discriminate against qualified job applicants or employees based on disability. In practical terms, this means that employers cannot refuse to hire disabled candidates or penalize disabled workers purely for their disabilities. Employers are required to make reasonable accommodation for disabled applicants and employees, which might mean making physical changes to the work environment or schedule changes to the workday.
So I wonder, now that we've gone through all of those different categories, if anybody has any questions about any of them. Okay, Monique, you must have done a bang up job.
They're waiting till the end, right?
Yeah.
Alrighty, so then moving on to legal theories under the EEO law. What are the primary legal theories that are used to determine if laws prohibiting employment discrimination have been violated? And I will let Stacy go over these two topics, but they are disparate treatment and disparate impact.
Great, Monique, thank you. So disparate treatment is really about employers treating applicants or employees differently because of a protected class. And the issue is that there is really there's some policy or some behavior or something that is present in the workplace that actually does have discriminatory intent. For example, a bona fide occupational qualification, a BFOQ, is actually related to duties of the job, and race or color may never be a part of a BFOQ. So the next slide gives you some examples of disparate impact.
Go back there. Sorry,
There you
Stacey.
go. Well, yeah. So disparate treatment is really being treated differently. Impact is when it focuses on whether or not an employer has a policy or qualification that on the face of it doesn't seem to be discriminatory, but in actual practice, it is against a certain group of protected classes. And so it usually focuses on procedures such as promotion or training or entrance exams. So the next slide has some examples of disparate impact. For example, African-American males are imprisoned more than white males. Now, I think we know that African-American males probably don't do as much crime as white males, or there's something wrong with the system that punishes African-American males more than white males. And so the issue is that there's something within that system that, although it looks like it's not discriminatory, it is having a negative effect on African-American men. The SAT and GRE tests use vocabulary that sometimes is not understandable by all types of people. And depending on how that vocabulary weighs out in terms of the test results, that can also be discriminatory. When you do internal searches to a company, so you're only allowing those that already work for the company to apply, that can have a negative effect on diversifying your workforce, because you can't hire, you can't promote, protect people from protected statuses if they don't already work for you. So I think the issue is that in some cases we are discriminatory in our actions or in our policies, and we mean to be. And sometimes we are unintentionally discriminatory based on the systems and policies and procedures that we have in place. So those are the two kind of legal standards that that the non-discrimination laws are based on.
Right. So if you believe you have been discriminated against, what should you do next? So before a complaint is filed, we would suggest making a written record describing incidents, including what happened, where, on what date, who else was present, and keep copies of anything offensive like notes, pictures, social media, voicemail, text messages. Of course, you can talk with trusted friends or colleagues, and consider informing the person that you want the behavior to stop, unless you fear that doing so would jeopardize your safety or your internship or your employment. And then where do I file a complaint? So we have two categories. There's employment discrimination and education discrimination. For employment discrimination, some suggestions are the local company, the parent company, the Washington State Human Rights Commission, the U.S. Equal Opportunities Commission. And for specific education discrimination, of course, CWU, the Washington State Human Rights Commission again, or the Office of Civil Rights, U.S. Department of Education.
When Monique and I were talking about this yesterday, I was telling her that if you are someone that's enrolled in an internship, you not only have coverage as the employment part, but you also have coverage on the education part. So let's say that you worked for, I don't know, a national pizza chain, and you felt that you were being sexually harassed at that pizza chain. You could call the local company. You could go to the parent company. You could go online and probably file a complaint there. But if you were enrolled in an internship at that company, you could also come back to CWU and say, as part of my educational experience, I'm being discriminated against at this pizza company, and ask CWU to intervene on your behalf, because we are responsible for those employment programs. And we would want to be able to help you to ensure that you weren't treated differently based on one of the protected statuses.
Perfect.
Are there any other questions? Okay.
Okay. So Stacy and I have some case studies that we are that we have ready for everyone. So if it's okay, I'm happy to read through them. What are your thoughts, Stacy? Should I read through them, or since we're a smaller group?
Sure. Why don't you, or I'll go ahead and read this one. How about that?
Okay, deal.
So this one is about Tomoko, and Tomoko is an Asian female who was recently hired as a recruiter for Smith University. She just graduated with a BA in 2011. That wasn't so short a time ago, 10 years ago. When she interviewed for the position, she was dressed fairly conservatively, and now approximately 5 months into her position, she's begun to wear a nose ring and clothes not typically worn in her work environment. So she is the picture of punk. I don't know if there's a picture of punk, but so Tomoko's recruiting results have been stellar, far exceeding the results of most of the other recruiters. And she has mentioned to colleagues that she likes the freedom to be herself at work, and she believes that her current look is at least partially responsible for those enrollments results, since high school seniors are close to her own age group. So Michael is Tomoko's supervisor, and based on the university's stated inclusion objectives and her recruiting success, he knows that her appearance is not a difference that makes a difference, but he also knows that it may negatively impact her success given the university culture. He has already heard passing comments from others about what body part she might pierce next or what outfit she might wear, and he fears that those remarks will distract people from seeing how hard she works or from the results that she gets. So Michael wants to address this with Tomoko in a constructive fashion, but fears she will interpret his comments as his own personal bias instead of seeing her feedback as being developmental. What do you think? What should Michael do? I'd really love to hear what you think. Anybody? Aaron.
I think you should talk to HR first off.
Thank you for saying that. Well, okay, let's say you're HR. What would you suggest that Michael do?
I guess it could be kind of a gentle kind of like, hey, just wanted to give you a little bit of feedback. There's an impression that I've heard secondhand. I'm not going to represent those people firsthand, but I just wanted you to know that there might be a little bit some negative perspective on this. I don't care personally, and you're not violating any of our policies. I know you're a great worker, but I just wanted you to know, and maybe know. And what do you think?
Great. I think that's a great way to start. I think some of it is about Tomoko's reaction, right? If Tomoko says, I think you're discriminating against me, or you're telling me these things only because I'm young, right? Then you know you've gone too far. But I also think it depends on Michael sets the tone in some ways. Like he's the guy that's setting the culture of the office. And so I think Tomoko is probably not the only conversation he should have. But I think he should probably have maybe a conversation with the rest of the staff that talks about the need for diversity in the people that are doing this kind of work. Because, you know, Tomoko's going to look great to some students, but she's also going to turn off other students. So I think it becomes this balancing act of who's, you know, you send Tomoko 1 month and you send someone else the next month. And that might be helpful in terms of moving forward. I know there's a follow-up slide here, Monique.
Mm-hmm.
What did we say on it?
Oh, I took it out, but I have the suggestions ready for us. So
That would be great.
So Erin was right on the suggestion to talk with Tomoko about her attire. And then we came up with Michael might offer Tomoko the opportunity to get a 360 feedback assessment. So really essentially what this could provide is information from her peer group or other colleagues that she could hear in an anonymous way that might not fall back specifically on Michael as a supervisor, but still provide her with any type of feedback that could help her growth within the organization. And then I notated about the dress code policy, but it seems like we've brought up some good suggestions about how to handle that, especially with what comments that Erin shared with us and you, Stacy.
Great. How about the next one? Here we go. Your turn to read.
All right, so we're moving on to case study 2. So for this situation, an employee, Sam, who's been to a few employee gatherings outside of work, sends emails to one of the other fellow employees, Charlie, in this case, which contains racist language and jokes. Charlie doesn't know Sam very well and doesn't know what to do. They swear they haven't given Sam any reason to believe that they would appreciate the emails. So in this situation, would you consider this harassment? And if so, what are Charlie's options in terms of dealing with the situation?
So does anyone want to help us out here? Would you consider this harassment? Kristen.
No, I guess for me, harassment would be if I've asked them to stop, if he's been asked to stop and then it continues. So, you know, I guess the first step would be saying, hey man, I'd prefer not to get those types of emails. And then if it continues after that, then yeah, I think that would, you know, could be construed as harassment.
It's interesting in the law, using racist language and jokes, one time does not make harassment, but it can be the beginning of harassment. But the other thing that's weird is it doesn't have to be Sam. Like it all can't fall on Sam to talk to Charlie. So Sam always has the opportunity to talk to his supervisor or talk to HR. The idea is behind the laws that Charlie has to know that this stuff isn't appreciated, right? And so more perplexing at times is the fact that if Charlie doesn't say anything and Sam continues to do this, you know, how does he find out that people don't appreciate this? Or how does he find out that the company doesn't appreciate it? Or, you know, or it moves from just putting up with Sam to being harassment. And so what I always tell people is it's really important to make sure that when you see these things that you let someone know so that they can let Sam know that someone has complained or that the company doesn't support this or it doesn't follow with the company's values. Because if you just let it go, you never know how far out Sam may go, right?
Mhm.
Stacy, I got a question. If this was personal email, would it just be between Sam and Charlie outside of work? Would it change anything?
Well, you know, it's interesting because I think email's different than social media, obviously. I think emails can be okay, but as I would tell Sam, if I ever got to talk to him, how you are perceived outside of work can certainly have an impact on how you are perceived at work. And so I think it's, you know, we all have freedom of expression and freedom of speech outside of work. But there's also stuff that comes to bear as a result of that freedom. And I think there is responsibility that comes with it. And so especially these days, we have a lot of social media stuff that goes on. And what I tell people is what you do outside of work is your privilege and your right. But that doesn't mean that it doesn't follow you into work and that people look at you differently or have a perception of you that's different because of what they know about you from out there. So, you know, let's say that Charlie consistently sends Sam racist jokes. Well, whether Charlie's at work or not, if I were Charlie, I would think he's a racist. Right? And then what happens is I don't give him a lot of slack at work. So if he doesn't get any forgiveness when I think about his behaviors. Is that kind of what you're thinking about?
Yeah, and secondly, if I got an email like that at CWU, I would feel very nervous that I even had my email associated with it, and I would totally tell whoever I would need to. Is there a policy at CWU that we just don't tolerate anything like that? We would just totally turn in somebody that would do that?
Yes, that would be one email does not a big discipline action happen. In fact, that's why I really like it when people come forward with this kind of thing, because then we can nip it in the bud right at the beginning, right? And make it very clear what our policy is. But using CW resources to promulgate racist language or jokes would be absolutely against policy.
Thank you.
Yep. Want to go to the next one, Monique?
Sure. All right, so case study number 3. Kelly was a production assistant at a TV station in a big city. Together with a videographer named Jim and popular reporter named Bill, She helped produce segments for the nightly news. Kelly loved her job, but felt uncomfortable when her colleagues made derogatory remarks about women's bodies, told sexually explicit jokes, and treated her like, quote unquote, one of the guys. Kelly sued in this situation for sexual harassment. When Kelly complained and asked them to stop, they told her, quote unquote, get with the program and stop whining. Bill told Kelly that she was lucky to have her job and that countless people would be happy to take her place. Kelly knew that this was true and stopped complaining. Soon afterwards, Kelly found Bill and Jim watching a pornographic movie in the office, realizing that Bill and Jim were not going to change their behavior on her account and that she could no longer work in what she considered a hostile work environment. Kelly resigned, and a few months later, she sued the station for sexual harassment, but lost. So in this situation, why did Kelly lose her case? She seemed to have a textbook case of sexual harassment that resulted in a hostile work environment. So we're on this one looking for what would be the reason why Kelly lost her case, or what could be some possible reasons.
Hey, Monique, can you just clarify, did she sue them twice or just the once?
Just once.
Okay.
Any ideas? So this is a very famous case. This is Burlington Industries versus Illerith, and it's the reason that Kelly lost is because Burlington Industries had a very strong anti-harassment policy, and every employee was given training on that policy, and supervisors were held to be very responsive to any complaints of sexual harassment. And Kelly never told anyone. So Kelly went back to the people that were harassing her, but she never told someone that had the ability to make changes in the workplace. They also showed, Burlington also showed that Kelly's career hadn't suffered as a result of the harassment, and that her colleagues hadn't asked or received for sexual favors in exchange for promotions or other jobs. I think since this case, there has been a lot of new court cases, but I still think that a company like Burlington Industries puts in place a lot of training and strong policy and training, not only for all employees, but for supervisors as well, in order to protect themselves. And they do require that Kelly, that someone like Kelly, at least let someone that's in power know, so that they can take corrective action when it's warranted. So that's another reason why it would be really great if you are experiencing some kind of discrimination in the workplace, that you let the organization know so that they can do something about it.
And maybe we can send this information too, but just to note on here, Stacy, that we have the FAQs on the very bottom of this slide that do talk about sexual harassment in the workplace. And so that could be a good reference material for anyone to look through.
Great.
And that concludes our presentation, and we're open for questions if anyone has questions. Or
Can you go back one, and I can put that link in the chat, or you could put the link in the chat. You could probably copy it, Monique, and I can't. Good suggestion, Wendy. Connor asked if with Kelly's situation, if they did anything to her or they just said things. I think they just said things. They didn't threaten her job. They didn't talk to her about negative repercussions in the workplace. It was all verbal. And again, it was all kind of in this collegial kind of atmosphere that included racist or sexist jokes. So Burlington proved in court that she didn't receive negative repercussions from the relationship with the two gentlemen. Okay, so we've got the chat, and Connor said he understood that. So Are there any other questions, comments? Anything we didn't cover that you'd like to know about?
I have a question, Stacy.
Sure.
You guys suggested that if people have a complaint that they can talk to the company, etc. But I think it was the Washington State Commission, or I can't remember the name.
Washington State Human Rights Commission. Yeah.
Right. Do you know what happens when people make a complaint to them? Like
Sure.
what that process is?
Yes. So when you complain at the Washington State Human Rights Commission, or one of the federal agencies for that matter, they have you fill out a form. And in the form, they ask you for the specifics, and they ask you what has happened. And they ask you under what categories have you been discriminated against or treated differently. They don't really ask for proof. I mean, they don't really give, you don't have to provide documentation that shows that any of it happened. They just ask for the rudimentary information about what you've experienced. What those organizations then do is they may call the complainant, they may want more information, they may ask for documentation, or in more cases than not, they send that complaint form out to the organization itself, the company, and they ask for a response. Now at Central, when we get those documents from the either the Washington State Human Rights Commission, the EEOC, OCR, etc., we sometimes haven't done an investigation into the situation because they didn't come to us first, and they don't have to. They can. Oftentimes people don't like to complain to the company. They like to go to a third party because they feel like there wouldn't be any bias or a conflict of interest or anything. And so that's fine. Our response to those complaints is great. Now we get an opportunity to look into this matter. So I would turn around then and do an investigation, or if I've already done an investigation, I would forward that investigation to the agency, and then the agency works with the complainant, provides that information to the complainant. We may have conference calls or different kinds of gatherings to discuss it. You don't, what you get from those agencies in response to your complaint is those agencies take responsibility for working with the organizations to make change in policy or practice or procedures or advertisements, or they will work with the organization to make change. They will also sometimes they don't make monetary, they don't move money from a company to a complainant. They can fine organizations for having violated a federal and state law, but they don't. If you want to get money as a complainant, if you want pain and suffering or actual reimbursement for something that you think some cost you've incurred, like counseling as a result of the behaviors, you have to go to court to get that information. And sometimes the Washington State Human Rights Commission or those federal agencies will accompany you to court. But these are long and drawn out processes, and not something that I wish on anyone. I mean, I feel bad for people that experience discrimination, and I feel bad for people that have to go through these long processes with agencies to get their issues resolved. They're just, in my opinion, they're just hard.
Thank you.
You bet. I mean, that's one of the things we try to do at Central, is to make the complaint process and kind of resolution as easy as possible. And when we get complaints from students, for instance, we try to do things like, if we find that there is sufficient evidence to suggest that they have been discriminated against, we try to get them remedies that meet them where they are. So it might be, if they've had to drop out for a quarter because of something that's happened, we might give them tuition for a quarter so they can come back and try to recreate a successful quarter at school. Or, you know, we try to figure out how to make them whole in some ways based on the discrimination. Any other questions? Okay, Monique, wrap it up.
All right. Well, we appreciate everybody for coming, and just know that if there's any questions ever, that we're here to assist, and don't be scared to reach out and talk about what's going on for you. So thank you all for joining.
Thank you.
Stacey, have a great rest of your day.
Thank you.
All righty.
Thank you, everyone.
Bye-bye.
Bye. How was it?